Thank you. Good morning. My name is Mark Chenoweth, and I'm the president of the New Civil Liberties Alliance, a nonpartisan, nonprofit civil rights group founded by prominent legal scholar Philip Hamburger to protect people's constitutional freedoms from the administrative state's depredations. I was also counsel of record on the amicus brief NCLA filed on the prevailing side in the Biden v. Nebraska Supreme Court case. NCLA represents nonprofit employer clients in multiple lawsuits against the department over its unlawful student loan debt cancellation proposals. These proposals injure our clients because they undermine the public service loan forgiveness program that Congress created. My comments today may be attributed to NCLA, but not to our clients. That said, PSLF employers that are negatively impacted by the regulations ED intends to propose should be included in the negotiated rulemaking process, as they are distinctly harmed and will have standing to sue over the regulations being propounded. The department must stop legislating new programs in the executive branch, which is not the proper branch for lawmaking. The vesting clause of Article 1, Section 1 of the Constitution states that all legislative powers herein granted shall be vested in a Congress of the United States. Article 1, Section 9 of the Constitution, the Appropriations Clause, ensures that Congress, not the Department of Education, will have control over federal expenditures. It provides that no money shall be drawn from the Treasury, but in consequence of appropriations made by law. Just as the department's attempt to use the HEROES Act to rewrite statutory provisions and cancel hundreds of billions owed to the Treasury violated both the vesting and appropriations clauses, so too any proposed negotiated rulemaking will do so if it cancels massive amount of debt owed to the Treasury without obtaining Congress approval. An HEA-based proposal could be even worse than the HEROES Act because it would not be limited to national emergencies nor to making impacted individuals whole. The Supreme Court just told this department that the major questions doctrine instructs it not to presume implicit statutory authority exists to sanction the creation of vast new programs based on vague or merely colorable language in old statutes. Yet here you go again. The Supreme Court will not permit agencies to discover elephants in mouse holes. Instead, there must be statutory clarity proportional to the scope of the power asserted. Finding blanket cancellation authority for student loan debt in the HEA, as this negotiated rulemaking aims to do, will amount to pulling a woolly mammoth out of a statutory mouse hole never meant for such massive undertakings. A vote of Congress is required before such a program may be instituted. Even if the Higher Education Act permits the department to suspend the law on a case-by-case basis, that does not authorize ED to invent wholesale exemptions. Moreover, as Professor Hamburger has shown, the U.S. Constitution forbids any executive dispensing or suspending power, including any delegation of such power to the executive. Canceling debt that borrowers are legally obligated to repay amounts to forbidden executive dispensation. That is, the power to act outside the law to relieve persons from a law that applies to them. English kings' exercise of dispensing power ended with James II, who was removed from power for abusing it, and American colonists never tolerated such power in the executive, and the U.S. Constitution forbids it. Indeed, the Constitution does not countenance such behavior for the exact reason why this administration is abusing the power. It would enable forgiving application of the law to the administration's favored constituencies.
15 seconds.
Such gratuitous conduct is simply not the prerogative of the executive. Allowing such behavior would also enable a complete end run of the bicameralism and presentment requirements under the Constitution for passing laws. The department should consult the Clinton v. City of New York line item veto Supreme Court case from 1998, which helps explain the constitutional limits. In sum, the department may only cancel debt under specific provisions of HEA where Congress pre-specifies the reason for cancellation and who qualifies. Congress has enacted numerous loan forgiveness programs using specific language since 1965. Those specific provisions would be rendered surplusage if general HEA language of Section 432A is read to permit the Secretary to cancel loans on a blanket basis. Thank you.